Hey, good morning, everyone. In Business Law 1, I'm going to review Chapter 8, which is about consideration for Business Law 1, obviously. And consideration in this context means something very different than we think of it being considerate, being nice and civil and decent to one another. Consideration is an element of any valid contract. There are some exceptions to the rule requiring consideration. We'll go over those as well. But generally speaking, we went over the previous elements of we have to have a mutual meeting of the minds. There has to be a clear, definite determination of what the parties are agreeing to, and it has to be seriously intended. The offer has to be made. The acceptance has to be the mirror image of the elements of the offer. The parties need to be competent, have capacity, and now we're in that third element. There needs to be some bargain for exchange. That's the consideration. Some exchange of legal value, it's called. Classically in typical business law, it would be money in exchange for a good. Of course, I'm searching my desk for a good. I'll use this pen. Let's say it's a nice pen and it costs, I don't know, $25 or something like that value. And I'm offering to sell you this pen that's slightly used for $5, and you get the pen. That's the consideration, my pen for your $5. But it can be much more than traditional money for goods. It can be also money for services. I'll pay you $2,000 to put 2 coats of paint in my house of latex. We get into some details if we're smart about it. That is a consideration of exchange for money for services. It can be services for services. Jim, you do my divorce and I'll paint your house or I'll repair your car. It can be an exchange of almost anything where the parties exchange what we consider to be legal detriment or a change in legal position that they have a right to possess or own. Sometimes it can actually be refraining from doing something. Say, for example, my house is of a certain height. I'm thinking about putting an addition in extending the size of my house by going up horizontally a little bit higher. And the neighbor across the street says, Jim, if you go up any higher, you're going to block my view of the pond, and it's really beautiful in the fall. I really love looking at it. And one of the reasons why we bought our house was because we had this beautiful view and you're going to be able to block it. Well, if I had a legal right to build that addition, but that homeowner across the street negotiated with me and offered me $20,000 not to build that addition, would that be valid consideration being exchanged between the two parties? Yeah, it would. Money is clearly a form of consideration, but me refraining from doing an addition to my home, which I have a right to do, and me not doing it is refraining from a legal right that I could exercise. So refraining from doing something that I have a legal right to do. I have to have a legal right to do it. Like, you can't say like, hey, stop beating me up every day at lunchtime for my lunch money. And I'll give you $1 every week if you don't beat me up. Well, I already have an obligation to refrain from illegal conduct. It's about legal refraining for kinds of things that I have a right to do. So the nature of consideration is very broad. It's basically changing of legal position as a result of the negotiation that occurred with the other party. We don't care too much, and I know I have a prompt that either is going to automatically pop up or I'm going to put it up over the adequacy of consideration. Generally speaking, bargains are out there in the community. You can have wide disparity in consideration, meaning that, say this was a Rolex watch. It's not, it's a Seiko. But say it's a Rolex, and objectively on the market, a used Seiko for a Submariner version, let's say it's $3,500. And I agree to sell it to you for $30, and we're both competent, right? Let's assume we're both competent, and there's no trickery or anything like that. And I agree to sell it for $35. But objectively in the market, it could probably fetch $35,000. Would that consideration be valid? A lot of you instinctively think, well, no, it's not valid. It seems fundamentally unfair. But if the parties are competent and they're freely entering into the contract, the law doesn't care about the disparity. That's why people are out there trying to do bargain hunting and get a really good deal on something. Now, we sometimes look at the gross disparity in consideration. If there is an allegation that one of the parties wasn't competent, or one of the parties was tricked, which is fraud, or there was a mistake of material fact. Geez, I thought that was an inexpensive Kmart watch. I didn't realize it was a Rolex. That's a material mistake of fact. And how do we go about proving it? Well, one of the things that would be evidence of that material mistake of fact would be the gross disparity in the exchange between the two parties. And that comes up every so often. You hear about somebody buying some land. I wasn't involved in this case, but I read about it where somebody bought some land that was probably, on reasonable assessed value would be about $150,000, and they got it for $1,500. Nothing illegal about it. That's valid consideration. Something was exchanged in exchange for real estate, $1,500. In and of itself, contract's fine. But later, when the seller of the land died, the family realized that grandma had sold some land when she was in a state of dementia, arguably. And how did they prove it? Well, they also brought in medical records and experts to show she was in a state of dementia for the last few years of her life, especially during the time in which that sale of the real estate occurred. But also, just in and of itself, there's an argument that you can glean some proof of lack of competency from gross disparity in the consideration being exchanged. But generally speaking, law stays aside. You spent $1 on something. It turns out you got something that you can turn around and sell for $50,000. The law doesn't really care unless we bring up those allegations about competency. In later chapters, we'll talk about also material mistake of fact, duress, undue influence, and fraud. All those might look at the disparity in consideration to help us determine whether or not there was, in fact, a flaw in one of the parties' ability to voluntarily assent to the agreement. So then it goes on to the next kind of what's not adequate consideration. And one of them is partial payment of a past due debt. This surprised a lot of people. So say I owe you $5,000 and I owe it to you today at 10 a.m. And at 10 a.m. I come in and I don't have $5,000. I have $4,000. And I say, hey, I don't have $5,000. I've got $4,000. And they say, okay, give me the $4,000. And I give them the $4,000. Could they turn around and sue me for the other $1,000? And a lot of people said, well, no, they just accepted the $4,000. But the problem is I owed them $5,000. I gave them $4,000. Even though they accepted it, that didn't give any consideration in exchange for the $1,000 reduction. So they can turn around and sue me for the $1,000. Even if they said, I'll accept the lesser amount. Yeah, I'll take the lesser amount. We're good. That surprises a lot of people. And that's why it's very, very dangerous for bigger contracts when somebody will say, yeah, I'll take a lesser amount of money, and then they turn around and sue you for the full original agreed upon. Right away, the court will do an analysis and say, okay, you were owed $20,000. You said you'd accept $15,000. And then the other party will be questioning us, well, what did you give the other party to get a reduction of $5,000? What new legal detriment was exchanged? Nothing. And that's a new contract. So in order for a new contract to take a lesser amount of money that's owed, past due debt, there has to be some consideration exchanged. So the book gives you 5 major exceptions to the rule. One is the amounts in dispute. You say I owe you $20,000. I say it's really $17,000 because some aspect of the contract wasn't completely honored on your end, I think. And so we're debating about whether or not it's a true $20,000 debt. So we say, in a spirit of compromise, to waive our claims of a dispute regarding the actual amount due, we will settle on the lower amount. That's actually considered a substitute for consideration, the amounts in dispute. The next one they give, if there's what we call a composition of creditors. So for example, and I've done this before, back when I used to do bankruptcy stuff, I got a client owes 10 different people, all different amounts of money, different, usually credit cards, for example, 10 different credit cards. And my client, for whatever silly reason, doesn't want to go through bankruptcy. I can contact all those credit card companies and say, hey, how about everybody take 25 cents on the dollar? You're all owed a certain amount of money, but everyone's going to reduce their debt by 75%. And that's a composition of creditors. There's multiple creditors. They're all agreeing to reduce their debt. And as a result of that, they're paying less money. The debtor is going to pay less money, even though there's been no new consideration given to the creditors. The law just created this legal fiction to help people consolidate debt. I don't know why it's there, to be quite honest with you, other than that, basically provision that sometimes, if I'm owed the money, for example, I'd rather have them not go through bankruptcy. I might not get anything. So in recognition of myself and other creditors getting together and reducing our debt universally on some proportional amount, the law is going to allow that to be enforceable. It's just a legal fiction. It was just created by the law. So it's called composition of creditors. I know what you're thinking. Thank goodness this is an open book, open note test because I'll never remember it. Generally speaking, if you pay less than what's owed, the person owed the money can sue for the balance because there's no consideration being exchanged unless you meet one of these 5 exceptions. First one, amount is in dispute. Next one, composition of creditors. And the other one is if there's a written note. So I owe you $20,000. And I come in and I said, geez, times were really tough. I really fought really hard to get the $20,000 due today at this time. I've come up with $18,000. Will you accept $18,000? And the other says, yes, I will. He goes, well, let's bring out the promissory note and you write on it, paid in full, and you sign it. You give me the note back. I give you the $18,000. That evidence of showing intent to be bound, I guess, is a substitute for consideration under these past due debts. It's just one of those things. You now hold, or I now hold, the promissory note, and they can't collect on it anymore. Just another substitute for consideration. The next one, I owe the money in a year from now. It's $50,000. I say, you know what? It's going to be really tough to make that $50,000. Will you reduce it to 40, but I'll also allow you to put a mortgage on my home. So if I don't pay a 40 next year, you can foreclose on my home or put a lien on my home. That is creating a new value. That actually is some consideration flowing to the other side, but they call it a substitute for consideration. It's a form of creating a security interest. It's not going to come up too much. The next one, gift. I can't read with my glasses on. I can't read them off. You hit a certain age, and there's this weird thing in between the two different distance and up close. My eyes are basically shot. But the other one's a gift. But careful. A lot of times I think a gift is almost implicit. So if I tell my friend, hey, I owe you 20 grand, will you take 18? And my friend goes, yeah, I'll take 18. Isn't it almost implicit they're waiving or gifting the $2,000 off the books? I think it is. But what the book is saying, it has to be overt. And so if you're ever dealing with that and you're the debtor and you're going to pay a lesser amount and the other side says, yeah, I'll take the lesser amount, ask him to write it up and say, I am gifting and forgiving the balance on this date and time. And that's evidence of gift. A gift, and we'll go into it in, I think, chapter 14. A gift is a willingness by the donor to give some property to the other person without consideration. And it has to have true intent, and it has to be delivery in it, and there has to be acceptance by the other side. It's pretty clear. But you do want to have probably a written memorial, some kind of writing saying, I forgive the debt as a gift. And those are the 5 exceptions to past due debts. Now, what's insufficient consideration? This is another one besides adequacy of consideration related to past due debts, is performing or doing what already is obligated to be done. And I'll bring up 2 examples. One's just fictional that I always love. Let's say, for example, I'm working at Lamont and I'm teaching in the traditional brick and mortar classes. I have to show up and come on the campus, but I'm notoriously late for my 8 o'clock class. I want to make sure my kid gets on the bus, so I kind of hightailing it because I live all the way down here in the Brimfield area. I make it just in time, but usually I'm 10, 15 minutes late because I have to grab a cup of coffee, get in class, and then, students are complaining. Say, hey, he's a good guy. Classes are great, but he's always late, and I'm paying for this. I want him on time. Let's assume the president comes up to me and says, Jim, we love you here at the college, but we need you to be here on time. I say, do what I can. He goes, I'll tell you what. What if he said, we'll give you a $5,000 bonus at the end of the year, full 2 semesters completed, if you show up on time every single day for all of your classes? I said, you know what? I'm going to take you up on that offer. Sounds like an offer, right? I accept. And I do it. I show up on time throughout the next 2 semesters. And then at the end of the semester, I come and I see the president. And I said, hey, did you talk to HR and the payroll people? Where's my $5,000 kicker? You promised me for showing up on time for class. And he says, hey, the budget's been really tough. We'd really appreciate it if you let us off. Oh, no, I'm not letting you off the hook. So I sue him for $5,000. Promised to pay me for showing up on time for all my classes for the 2 semester. Once they talk to the attorney, they're going to have a slam dunk case, because guess what that attorney or even anybody that's taken this class is going to know? Wasn't I already contractually obligated to show up on time for every single class for both semesters? Yes. So there's no enforceable contract. I haven't given anything in exchange. I already had the legal obligation to do that. And that comes up actually a lot in contracts for construction services. And this is a real life example. My buddy, he's got a great first name. His name is Buster. Buster did a contract, and he was working for this, I think, wealthy family, because I used to stop by when I'd come home from my law office, and I'd see him sometimes working, and I'd see his truck. And I'd say, I'd stop and have a coffee with Buster, and I'd go over and talk to him, and he was building a deck out of, I think it was cypress. I mean, it wasn't even like, well, now everything's made out of the composite, but it doesn't matter. I just never saw anybody making a deck out of cypress. And, so it was like really high end stuff. He's doing a great job. And he did a lot of work for these people. And it was a very impressive old farmhouse. And I always kind of fell in love. It actually went for sale not too long ago, and I was hoping to buy it. It was a lot of my league. But Buster was telling me, he goes, hey, people are treating me really great. They pay really well and everything. He goes, and I'm almost done with this job. And they said they're going to give me I think he said he's getting $2,000 bonus, like at the end. He goes, why? He goes, well, they're just really happy with my work. I said, good for you. So, I don't know, 3 weeks goes by, month, whatever. Who stops down my office with a coffee but Buster? And this is maybe 15 years ago. And he comes to my office, I hear him coming up the stairs, and it's him, and he says, hey, Jimmy, what's going on? I said, he goes, hey, remember that job I was doing over there in Brimfield? In Sturbridge. I said, yeah. What's up? And he goes, remember, I don't know if I told you, but they were really happy with my work, and they said they were giving me a $2,000 bonus. And when all was said and done, I put my bill in, and they gave me the amount that was in the contract, but they didn't give me a $2,000 bonus. So did you give them a call? They did. And they said, things are a little tighter right now, and they're just going to pay the contract price. He goes, do I have a claim against them? It's a good question, but you know the answer now. No. Why? For Buster to get the additional $2,000, what additional thing did the homeowner get? What did Buster do in exchange for that promise? Nothing. He didn't add better materials. He didn't finish the job quicker. The homeowner got nothing new. There was no bargain for exchange. There's no consideration. And so that happens a lot. And so I always told Buster ever since then, I said, hey, if a client ever asks you to do something new and you expect to get paid for it, make sure it's clear what's going to be exchanged. You're going to do this new added feature, but they're going to pay you more money. Or if they just simply say, we're so happy or whatever, we're going to give you some more money at the end, say, because you're giving me more money, I am going to finish this project a day early. Or I'm going to add a second coat of polyurethane to the deck. Or I'm going to add a fancier spindle on those guardrails. It doesn't have to be equal. So for the $2,000 he was going to get, he could add something really modest and trivial. And put those little sticky paper things on the treads so you don't slip in the winter. I don't know. You got to have something exchanged for it because you're already doing what you're supposed to do. There's nothing new. The next one, refraining or promising to refrain from what one has no right to do. So, well, I guess that's a bad example. I was just thinking, some of you might have Professor Dan Susi at the college. He's sort of we had in the same suites, and whenever I go by his office and I can tell he's seriously, doing something very intensely, and he's a deep thinker, I always knock on his door until I get his attention, and then I just walk away. That's not a good example, but this is about things like if somebody comes up to me and says, Jim, I'll pay you to stop committing some crime. Let's say I don't know what crime. I'm blowing through the red light in Sturbridge every day when I'm leaving for work, and some neighbor always sees me doing this. Jim, I'll give you $100 a month if you no longer go through the red light. I say I agree, and for whatever reason I have some method through, I don't know what do you call those things, those not sport cams, I don't know, action cams. My kid has one, he goes mountain biking on a thing. Gear Pro, Progo. Now it's going to bother me, give me the name. But I document that I always stop at the red light now, and now I go to collect my money. That other party has every right to say that's an unenforceable contract because what you were refraining from doing, violating the law, is an obligation you already have to do. It sounds like common sense, but it's the same. It's the same as that bully example I gave before. I'm used to beat you up all the time, and now you're going to pay me money not to do it. That's an invalid consideration because I already have a legal obligation not to beat you up. Hopefully common sense. Past performance we already talked about. One that already has past performance comes up where there was an example in a movie I used to show, but because of copyright, I can't post it up on the blackboard. There's a retirement party for someone. They did a great job. And they said, we don't, maybe the person had a 401k at that company, but there was no pension plan there. But the company's doing well at the time. And the president at the party says, we're so happy with Ted's service for the past 30 years. We're going to give him a $500 pension for the remainder of his life per month for all the great service he's done for us. And everyone's so happy. Good party. Party's over. A month goes by and Ted's wondering where his $500 kicker's coming in. I always call it a kicker when it's something on top of what you expected. And Ted doesn't know where the money is. He contacts HR and goes, "Oh, the president of the company said not to do it because things are tightening up and the economy is shifting in a certain way." So Ted sues. Will Ted win? No, because what did he give the company in exchange for the $500 a month pension for the remainder of his life? Nothing. All the things he gave the company were already completed. He retired. There's no new consideration there. Now, what if he said at the retirement party, "I'm going to work one more year as a result of you promising me that $500, or I'm going to stay on for 90 days to help my replacement to really get to know the ins and outs of their duties in my old position before I leave because you're giving me this." Now there's value exchanged. It doesn't have to be equal in any way, shape, or form. It just has to be some legal change in circumstance between two parties. I think that's pretty clear. Book does a nice job. Past performance. Now the exceptions to consideration. One is voluntary subscriptions, and I hate the term. I always think of getting a magazine, therefore you have to pay. It's not about that. Voluntary subscription means you're making a pledge to some charitable organization. There's a debate about what a charitable organization might mean, but certainly anything that's what's called a 503c, I think it's called, under the income tax return. Basically, these charitable organizations that raise money for societal needs, for the poor, for every kind of thing you can think of. It could be for sick animals, who knows what it is. But if it's recognized as a charitable organization and you pledge to donate $100, they're not giving you anything in exchange. But the law says in order for beneficial societies and organizations to have some degree of integrity and dependence upon promises of gifting, those gifts have to be enforceable. In fact, if you like The Simpsons as much as I do, there was an episode where he was watching Homer Simpson's a cartoon character. He's kind of a bonehead family guy, older guy, and he's watching PBS, and the show was called, I always remember this, British Men Behaving Badly. And he's watching and he's really into it. And it's just guys hitting each other over the head with frying pans. He thinks it's hilarious. And they break away for a fundraiser. And Homer Simpson's really outraged. But they have this, they show the people in the background on a telephone bank. It says, if we can just get $10,000 in pledges in the next, time, we can go back to British Men Behaving Badly. So Homer dials in anonymously and pledges the $10,000. But of course, they figure out who he is and they go to collect it. And it's really silly because it's PBS. So they send all the monsters from Sesame Street to go collect it from Homer. He has to take flight. He seeks refuge in some kind of remote island somewhere, and he becomes some kind of a religious leader for these indigenous groups in some remote island that hasn't met with Western civilization. It's ridiculous, I know. But the point is if you do call and pledge money to a charitable organization like public television, could that be enforceable against you? And arguably they are giving you something. They're giving you, access to public television programming. And that's what the government has said when it comes to these subscriptions, meaning pledges, promises of donating goods, services, or money to charitable organizations. They're enforceable because there's a sense of consideration that it benefits society as a whole. It's a legal fiction. Debts of record. Debts of record means simply there's a judgment in court that you owe $20,000. You don't have to say, well, I never got any consideration for that court order making me pay $20,000. It doesn't matter. The court's ordered you to pay $20,000. You have to pay it. Now the big one in the book, you could have a whole chapter on this next one. It's promissory estoppel. And you have to have all four elements in order for promissory estoppel to apply. And legal terminology does tend to scare us, but think about it. I think of it as a promise that can't be pulled back. I guess it's a more simple way of saying it. But think about it. The other party didn't promise you anything. So I'm thinking about this. I have a two-seater car, and I have a bunch of kids. My daughter now just got her license, so she's using my other car all the time. So I got this two-seater car. Now I have to drive it all the time, and you can't really drive it in the winter. Winter's coming up. So what if somebody came along to me, a friend, that says, Jim, don't go out and buy that car that you found on Craigslist. It looks like a really good bargain. In fact, sell your two-seater, get rid of it. Next week, I will give you my car because I don't need it anymore. And you've always been a great friend. You always help my family, blah, 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 blah. I'll give you my old 2010 Subaru. It just runs great. It's great in the winter. It's a good beater for a while. This will hold you over. And I'm like, really? You promising me to do that? He goes, yeah, but you promised me you'll sell the Roadster you got and promise me you won't buy that car on Craigslist because you'd be wasting your money. Okay, I won't do it. I'll wait on you next week, but I'll sell my Roadster in the meantime because I don't have to go anywhere in a week. I actually sell my Roadster. I don't buy that car on Craigslist, but I'm not giving anything to my friend in exchange for this. Can I enforce that promise? Let's look at the elements of promissory estoppel. First, a promise is made. My friend promised me to give me his car. The next, the promisor reasonably expects the promise to induce action in me. Did it induce action in me? Well, not only should he expect it, I did act. I sold my Roadster and I refrained from buying another car that I could afford that was available. Next, the promisee does act. Well, that's implicit in number 2. And then the fourth, justice requires enforcement. Now, what do you mean by justice requires enforcement? We don't want promissory estoppel to apply all the time. We want it to apply when the promisee, me in this case, would be very much detrimentally harmed. Let's assume I'm on a really fixed budget and I just don't have the money to go out and buy a different car, and my Roadster is now gone. I have no wheels at all, and if it wasn't for that promise, I'm going to really be in Dutch. I'm going to be in a lot of trouble. That would likely be enforced. This used to come up a lot in employment contracts. And if those of you have ever gone to an interview, sometimes they'll leave and ask you to sign a statement that you recognize that today's interview was not a promise of employment. Because the other example I give, because it's often argued in employment contracts that, hey, this company offered me a contract of employment, and as a result of that promise, I quit my other job, I sold my house, I moved to the area, and now I show up for work and they're saying, we're moving in a different direction. I want that contract enforced. And so employers have to be very cautious not to seemingly make a promise of employment to a candidate if they're ambivalent or not sure they're going to go through with it. And I always joke around making that example that I'm at some conference of legal educators or historians or whatever. And I always one of my dreams is to live by the ocean. So I don't know, I'm up and I meet some people from Cape Cod Community College or maybe from Roger Williams University or Endicott College, and see I've done my research. These are all the colleges that are right near the ocean and still staying in New England. And say I'm at something and they met me before and they saw me do a lecture or something, or hey, you'd be great at our college, and an opening came up. It was really, really. And what if they told me, says, Jim, you're in. You can start fall 2023. Got some time to think about it, but here's what we want you to do. You got to give the Mount notice, quit the Mount, sell your house out there in Brimfield, bring the wife, get rid of the wife, whatever you want to do, close out your ties up there, give up your law practice in Worcester, maybe start doing something down here in Rhode Island near Roger Williams. And so what do? I do all those things. I quit the Mount or give my notice. I sell my house. I find a house near Roger Williams near Narragansett Bay, and I spend more money than I can afford. I'm all excited about starting. And then I go over there and I say, hey, when do we set up the class lists and things like that? And where's my office going to be? And they say, no, we decided there's a really low enrollment. Things aren't going so great. And a friend of a friend really needed the job, so we gave it to them. My argument, promissory estoppel should apply. You made a promise to me to hire me. It was likely to induce behavior on my part. It did induce behavior on my part to my detriment. And justice really requires enforcement, or I'll basically lose my entire livelihood. Promissory estoppel is a big deal. It's the wild card. When you can't prove there was an exchange of promises to one another, how can you establish that the other party should be forced to pay you damages in some fashion? And it's promissory estoppel they bring up all the time. Now, this has literally one sentence or two sentences. Two sentences in your book. It's an important exception to the rule that in order to modify or change a contract, you have to have consideration. So going back to like the Buster example, Buster says he's working on my house and he's putting a new kitchen in. And he's saying, Jim, this is a real pain in the ass. It's a lot of work for $5,000. I didn't think things were going to be this difficult for me. And he says, I really wish I could get some more money out of you. And I said, okay, it's for $5,000. I'll give you $6,500. I'll give you another $1,500 because the work is so difficult. And at the end of the job, do I have to give him the additional $1,500? Has he given me anything new? No. So therefore, the other $1,500 wouldn't be enforceable. But what about this? Because, Jim, this job's been a real pain in the neck. How about I upgrade the counter service from quartz to granite or vice versa? I don't know what's more valuable. I found the one you really like. I'm going to change the work order, but I need you to get another $1,500 from me. Yeah, now it's an enforceable agreement. The modification's enforceable because modifications are new contracts. So any new contract needs to be consideration flowing back and forth. Always true with one major exception. The laws recognize that for convenience in the sale of goods, movable identifiable objects, not real estate, not services, we got to create some flexibility. So as long as parties voluntarily agree on the sale of goods, you can modify those contracts voluntarily, even though no new consideration is flowing back and forth. I don't know why I always use ball bearings, but let's assume my company is going to buy $500,000 ball bearings for $50,000. Ball bearing company calls me up and goes, Jim, the price of steel has skyrocketed. We're going to need $55,000 for 500,000 ball bearings. You need another $5,000 from me? Like, Jim, you're just going to, it's going to be tough for us. We're going to lose money on this thing. We've worked together for 20 years. Because you know what? We have worked together for a long time. And I can up my price a little bit of my end product. And I know you're not ripping me off. And I have read in the trade journals or whatever that steel's going through the roof. Caught you by surprise. I'll pay you the other $5,000. Now, under the whole thing I just told you for this review, that would be an unenforceable contract for the additional amount of money. But because of the need for flexibility when it comes to only the sale of goods, they're going to allow that modification to be enforceable between the parties because they did it voluntarily. They were clear in their intent. And because it's the sale of goods, we want the parties to have flexibility. And so the old rule used to be, even with the sale of goods, some new consideration had to be flowing back and forth. Not anymore. Modification for the sales of goods does not need new consideration, provided the parties are in voluntary agreement to change those terms. However, if I was the ball bearing company, I'd say, well, get the shipment out a couple days earlier, or something like that, or add just some little minor new feature in terms of legal shifting to make consideration flowing back and forth. I think the book does a nice job. I just feel obligated to put up some kind of discussion as if we were in class together, get a feel for what I think is important. Look at the chapter, read it a couple times, look at this video, hopefully, and it's probably not nearly as good as some of the other videos I probably posted, but otherwise, never be afraid to ask a question. Never be afraid to raise an issue. Hopefully always here for you, and there's no such thing as a dumb question. I really mean that. Be well.